Leading local tonight, Burleigh County's District Court heard arguments today on the abortion trigger ban. The argument, whether to issue a preliminary injunction blocking North Dakota's trigger law. The abortion ban is set to go into effect on August 26th. That's a week from today. Adrian Oglesby has more from the courtroom.
Soon after Roe v. Wade was overturned, the last remaining abortion clinic in North Dakota filed a lawsuit. In court today, Lauren Bernstein, attorney for the Red River Women's Health Clinic, argued that the ban violates the state constitution, requesting the courts to block the law while litigation proceeds. Bernstein's argument was the ban is and will cause irreparable harm.
It's hard to imagine a harm more irreparable than losing your state constitutional right to make free choices about having children.
The plaintiff attorney went on to say those consequences could be financial or emotional. She also brings up research showing pregnancy and giving birth is 14 times more dangerous than abortion. However, the state rebutted, saying the injunction should be denied because there is no fundamental right to abortion.
The court should reject this argument. First step in analyzing this issue is to determine whether or not the fundamental right to abortion expressly or impliedly exists within the language of the Constitution.
He says the language is broad. District Judge Bruce Romanek pointed out that the state presented no facts, hard evidence, or affidavits.
I got 2 affidavits from plaintiff, mostly focused on the clinic. Some reference to, doctors will be impacted, and then of course patients if doctors are impacted. I got nothing from the state, no affidavits countering their affidavits, no evidence from your side. I have argument, get that.
The state replied by saying they only had 7 days to reply to the motion and that their argument relies primarily on the law. The plaintiff attorney ended by saying,
North Dakotans do not want the state to restrict their personal health care choices. The Cromwell decision from the state Supreme Court in 1943 explains what this happiness right means, and the court in that decision, in a very lengthy decision, explains that happiness is an expansive right that is not capable of definition or limitation, and it includes the privileges of the family and home. Losing this right it's very difficult to think of a harm that's more irreparable than that.
District Judge Bruce Romanek told the court he will have a decision on the motion by the end of next week before August 26. Reporting for KX News, I'm Adrian Oglesby.
If Judge Romanek motions the injunction, it'll go into effect and the restraining order would come off. If he denies the restraining order, then it will be removed and the statute will go into effect.